Okay, we're live. So first live stream for as far as the case goes. So bear with us, everybody, in case we have any technical difficulties. But this is Lorraine the Lawyer. We're going live on my channel right now, and then after the stream, I'll be uploading the video to her channel. Everything is linked down below. And Lorraine, why don't you kind of give just a quick background on who you are and yeah, before we get into the Def Noodles and Keemstar defamation lawsuit.
Sure, I would be happy to. So my name is Lorraine The Lawyer, and I am the managing attorney of a law firm by the name of The Lawyer Law Group. We are an international law firm focusing on actually a lot of business transactional as well as immigration matters. Our mainstay is transactional. However, of course, our attorneys have a background, a very multifaceted background. And so I'm very happy to be with you today. I tend to work with actually a lot of influencers, people from not just have now in the US, but abroad, elves in the United States. So I actually have worked with many influencers over, gosh, more than a decade now. And it's a true honor to be with you all today and talking about this very important case that's come up here.
Amazing. Yeah. And why don't you also give everybody like 3 things you might not guess about you, like personally, like about you and your background or something you like to do. So
sure. Absolutely. Sure. Yeah. So I work with, as I mentioned, I work with influencers. I also work with a lot of artists. And in fact, I was one for quite some time myself. I was a model. I modeled for Ford. I modeled internationally. And it was a lifelong dream actually to be an advocate for those that, are getting their content out there, representing them, working hard to, get their brands out there. Also work with them as they're expanding their businesses internationally. And so I went from model to lawyer, which is, I guess, kind of a unique journey. And I'm Canadian, as you can probably tell from my accent. Originally
I could never really tell your accent, but yeah, we'll have to get you on a stream with Viva.
Yeah,
Fry, because he's from Canada.
That would be awesome. I love that. I mean, Drake and Ford Nation, some say put us on the map. So here you go.
Love it.
Yeah, well, we're a lot more than beaver tails and maple syrup. So I hope it'll be quite entertaining for you all today, and yeah, make this a little more digestible, this lawsuit.
Yeah, so it's funny because I've been watching the lawyers that have YouTube channels that often collaborate, and I think Emily D. Baker was on somebody's stream and she said something about Def Noodles, and all the lawyers were like, we don't know what you're talking about. So this is, although it's sort of like mainstream pop culture for the YouTube world, I feel like it's not totally mainstream. So I think it's great that you're going to cover it, and yeah, let's get into it.
Yeah, let's
also, just for you guys, so just for your background, Lorraine kind of came into this completely unbiased because she doesn't know either of the creators. And I was on Def Noodles podcast, but I also was Keemstar's next door neighbor at one point. So I don't Keemstar and I are cool, and so am I with Dennis. So and I have my own defamation lawsuit. So I'm just very interested in this realm. And Lorraine did all the homework. So let's get into it.
Yeah, let's go. So let's lay over some facts to start off with here. So the case, this case was actually filed in the Western District of New York Federal Court on May 19th, 2022. It's a federal case, in large part because the plaintiff, Dennis Feitosa, who is actually living in Los Angeles, but then the defendant, Daniel Keem, lives in New York. So since the plaintiff and the defendants are residents of two different states, and the amount of money in controversy here is over $75,000, so the amount that claimed in damages, the federal court is the proper venue here. Plaintiff Feitosa is asking that the California law apply to this action because he is a resident of California, and the statements that defendant Keem made caused and were meant to cause the most damage in California. So Dennis Feitosa, our plaintiff, goes by the name Def Noodles on social media, and the defendant, Daniel Keem, goes by the name Keemstar. So there's our background for the next little while. Both are primarily active on YouTube, and they both have a lot in common. They're competitors. They each have T channels, which is slang for gossip channels, that focus primarily on other YouTube and social media personalities. Both plaintiff and the defendant had made a career of bringing over the top, often very untrue or greatly exaggerated gossip and news to their viewers. And both of them are direct, of course, as I mentioned, direct competitors in the social media arena. So what are our causes of action here? And I'd like to lay out some definitions so that things make sense as we move along here, myself and my friend Ari. So the case arises out of a statement that the defendant, Daniel Keem, made on May 21st, 2021 on his Twitter account. He posted the following about plaintiff Dennis Feitosa. Def Noodles has allegedly groomed girls from ages 12 to 15. Big YouTuber source. Victims are scared of him and wish to stay anonymous, but may come forward soon. Hashtag drama alert. Def Noodles has declined to give us a comment on these allegations made against him. So this lawsuit is for a single cause of action, libel per se. Libel per se is defined as a defamatory statement that is actionable in itself. The statement by itself is damaging to the affected person. If the words can reasonably be interpreted to have another meaning, then it's absolutely not libel per se. Whether something is libel per se is generally a question of law then for the court, not a jury, to then decide. And the standard that's articulated in California for libel is essentially anything that is damaging on its face without further explanation. In a case of libel per se, malice is presumed and damages may be recovered from the defendant without having to show special damages. So plaintiff Feitosa is acting for actual compensatory and exemplary or otherwise punitive damages for at least $75,000 against defendant Keem. So let's look at the basic fact pattern then of the case and the damages along with the damages here.
Okay.
So
I was going to try to pull up the thing because I can that way. I can also pull up like the tweet.
Let's move along with,
Yeah, I'll do that.
All right. So ready to go or no?
Yeah, hang on one sec. Sorry.
Yeah. No, okay.
All right. I'm trying to find it. Yeah. Keep going and I'll pull it up.
Okay. All right. So on May 21st, 2021, Daniel Keem, otherwise known as Keemstar, tweeted the above tweet, then saying that defendants Feitosa Def Noodles has allegedly groomed girls ages 12 to 15. Okay. So on February 5th.
Did you say allegedly in the tweet?
I'm saying allegedly.
Oh, okay.
He stated.
Okay.
But notice I said Def Noodles. I didn't say Dennis Feitosa.
Okay,
So on February 5th, 2022, Keemstar then tweeted, "Don't you remember plaintiff Feitosa, kept posting nonstop fake pedo stories on YouTubers, so I posted this tweet to mock him. In May 2021, everyone knows this is a joke that I'm mocking him, but now he's taking it completely out of context, acting like it's a serious allegation.
He posted that 8 months later, though, right?
Right.
Okay.
Yeah, good note. So defendant Keemstar also reposted the statement that Def Noodles had declined to give us a comment on these allegations made against him. So that was reposted.
Okay.
Allegedly, the defendants, right, also had blocked Def Noodles from the defendant's Twitter account. So Def Noodles couldn't even answer, even if he wanted to. So for 8 months.
That's what okay, this is a complaint.
Yeah.
Okay.
The complaint.
Got it.
So for 8, and then I'll go into the dismissal, request for dismissal, of course.
Okay.
So for 8 months, Keemstar allowed the statement to sit in the public sphere, where various viewers then comment on it or seem to take it seriously. So allegedly, multiple people also tried to contact Def Noodles for comment regarding these allegations. It's really interesting to note here that the plaintiff, Faye Toza, is also using the retraction as clear evidence that the original retweet was malicious. And apparently the logic goes that he, Keem, the defendant, made the original tweet, then retracted it 8 months later. And that tends to show that he made the original tweet maliciously, knowing it was false. So damages are immense, compensate. Damages are for compensatory.
Compensator?
Yes, sorry.
Okay.
In excess of $75,000 plus interest, mental anguish damages to be proven at trial in excess of $75,000 plus interest, punitive exemplary damages for defendant Keem's conduct, and other relief as the court sees fit.
Okay, let me find this on the screen really fast.
Sure.
Oh, this is the response. Shoot. Okay. All right, here, I'm going to put us back on here and then I'll find it. All right, yeah, go ahead. I think it's on our our WhatsApp chat, so we'll keep going.
Okay, so let's look. I think we should really dig into the background of both parties here and the genre. The definitions I just went through, the facts and the cause of action, we can pull it all together here. So both Keemstar, because it definitely gets confusing, I think, even for lawyers here. So both Keemstar and Def Noodles belong to a genre of social media stars who are active primarily on Twitter and YouTube, and then also specialize in drama about other social media personalities. Both of them are in competition with each other and have a long history of talking badly about the other on their respective platforms. So Def Noodles was actually banned, interestingly enough, from Twitter on July 15, 2021 for unspecific but repeated rule violations. On his other social media platforms, Def Noodles has accused Keemstar of getting him banned from Twitter by having Keemstar's followers report Def Noodles' channel and content. While it seems that Keemstar had some very fast insight into when Def Noodles was banned from Twitter, apparently knowing even before Def Noodles knew, it seems really hard to believe, and this is a takeaway here, it seems really hard to believe that somehow Keemstar could manipulate Twitter into actually banning Def Noodles just by mass reporting, right? So either way,
Keemstar has a really loyal. I mean, I've been following both of these guys for a long time. So Keemstar has like a bit of like an army, right? So when he has all these people that follow him, and I've seen it in the past. I wonder if they're going to pull up past instances of this, but where there's actually been several big accounts that have accused Keemstar of allegedly working with, I don't know if it's like bots or he works with like they've accused him of working with like basically getting on like what is that? It's called Discord, and then basically everyone in the Discord then tags somebody or flags something. This is something where I think they could potentially have some trouble here because, like I said, somebody like me who understands how the internet works and how these people communicate and stuff like that, I get it, but maybe a jury or a judge is not going to fully understand it.
Right.
or even
Okay.
believe that it's possible. Like you're saying, it's kind of hard to believe that somebody could initiate all these people, but actually they can. And so maybe it's going to be important for
Mhm.
each side to have examples of what they're talking about.
Interesting. Okay. Interesting. Okay. Well, honor. Okay. So, yeah. So either way, Twitter won't comment except to say that it is a permanent suspension and that it was for repeated violations. So they are saying that. And the suspension was apparently lifted by Twitter in July 2022. So
Okay.
on or about August 2nd, 2021, Daniel Feitosa said that he was retiring his Def Noodles personality from social media, but was still going to keep doing gossip videos in the same vein, just not using the Def Noodles personality. Since that time, he has in fact brought back the Def Noodles personality. So even so, so that's a difference from what he stated previously. As for Daniel Keemstar, he got his start being an online. So obviously, more, but I see it, from an online troll or bully, I guess, in the video game Halo 3 in about 2014, when he then joined the Federation of FAG, as bleep gamers, right? With the mission to essentially troll and bully gamers. So in
I don't know. I
2016,
know he's really good friends with the guys from like I think he was friends with the guys from the big gamer, like there's like a big phase group, because that's why they rented one of these huge houses in the hills, and I had a room. It was on Weed Lake, this street in Hollywood, and he was part of that whole kind of group of people, of gamers. That's
oh,
where I remember him. And yeah, it's kind of like a daily show. It's like the Daily Show, or your daily gossip, Perez Hilton sort of
okay.
thing. And Keemstar really did sort of pioneer that space, I think, online, as far as I remember.
Okay, interesting. In 2016, Keemstar publicly accused a popular Runescape video game Twitch streamer as a pedophile named John Phillips. And this caused extensive harassment against the accused streamer, who actually broke down and showed people his identification during a stream to show that he really wasn't John Phillips.
Okay.
As a
Yeah,
matter
let's
of
just
fact,
say P word. Let's say P word so that they don't like stop my stream.
oh yeah, of course.
Yeah,
Sorry.
no, you're good.
Sorry. Um, uh,
I know, gotta
as a
love
matter of
YouTube.
fact, yeah, okay, got it. As a matter of fact, the real John Phillips was currently in prison at the time. So a case of mistaken identity, but apparently part and parcel for the kind of thing that Keemstar does or on his own
Okay,
channel.
got it.
So there are a lot more examples online, but we just leave it at that, because they come from some sources that they don't seem to, do necessarily their homework on. There's a lot of information out there. It was hard to, pull from. So anyway,
Yeah.
I would say
And
that.
oh, go ahead. So you're saying that, did it allege in the complaint that Keemstar has done this before, or no?
I believe so. I believe so from my notes. Sorry, I was working on this pretty late last
No,
night.
you're good. You're good. Go for it. No, keep going.
I believe so. I'll check on that. And these are all my notes from going through it. Yeah.
Okay, cool.
So the fans' reaction and then defenses. So since news broke out of this lawsuit, people in the T genre of social media seem to have really mixed feelings about it. A lot of people seem to feel that Def Noodles said such ridiculous things about others that he should have expected something like this to be said about him, or that he actually deserves some slander directed towards him. Def Noodles is no stranger to controversy, though, and has feuds with several other content creators, usually ending in insulting tweets, snarky videos, and in some cases, even yelling matches. The most common defense is defamation, is truth. So the most common defense is truth to this. And in this case, Keemstar would have to prove that Def Noodles was in fact engaging in the P word with such young girls. Since this doesn't seem to be a very realistic defense, and since Keemstar retracted the entire statement, this doesn't seem like a viable way to defend. So just as
so okay. So okay, so I guess on Keemstar's side is that he retracted the statements, correct?
Mm-hmm. Correct.
So you would say that that's going to be looked at. Do you think that the amount of time that it took to retract will matter?
Yes, definitely, from a punitive damages perspective.
And then in terms of the controversy towards Def Noodles, the plaintiff, I could kind of explain that for anybody that's watching that doesn't know what we're talking about, is that recently, this is after this lawsuit has been filed, but more recently, Def Noodles said something to the effect of another YouTuber looks like he could be a pedophile, or P words. Probably gonna get dinged anyway. I know. So Def Noodles said, oh, like, in what he's saying is, as a joke, he said, this guy looks like he could be a P word, something to that effect. I got to find the exact right thing. I think the difference here is that, and I guess what they're sort of arguing is that Def Noodles is saying he's a comedy account, so that's what he does. And I've honestly seen other comedians say all sorts of things about people's looks, like Andrew Schwartz or whatever his name is. He talked. There's people in the crowd right in front of him. He'll say, "Oh, you look like an R word, or you look like this, or whatever." But it's said in jest. Okay. Obviously, I think the tough thing on why people are ethically sort of saying, maybe not legally telling Def Noodles, okay, well, this isn't cool, because he didn't like that creator that he was calling the P word. So they're like, that's actually done in mean-spirited, not for laughs. And so whatever. So that's one part of it. I think the other part, and the part that's put in the lawsuit, is that Keemstar has bragged about actually putting other people in jail. As far as I know, as he's allegedly helped put people in jail. I know in 2018 or 2019, I think it's 2019, Keemstar had a girl on his YouTube where they were sort of reporting the news, in that there was an alleged P word or statutory R word situation for this influencer named Ray Diaz towards another girl, and then I believe everybody was told to tweet at the LAPD, and then the LAPD actually responded and they said, hey, we're aware of this viral video, which is, like, in 2022, that seems odd that somebody, that the LAPD would investigate just based on a viral video, because in today's world, you would think, then why isn't James Charles being investigated? Why aren't all these other people being investigated? But I think, to that effect, Ray was actually arrested, and I think he's still in criminal court due to those allegations. And so I guess the seriousness is based off of the fact that, Keemstar's channel is not just a joke account, and that they have put out sort of serious allegations in the past that have led to criminal investigations and whatnot. Allegedly, I don't know for sure. I haven't talked to the police, but so that's how I was looking at it, as, okay, I understand why people could be mad at Def Noodles. But do I think, I think that if Keemstar had a case, he would have probably countersued, right? Or had something to that effect. I mean, maybe he was past the statute of limitations for defamation, which is like a year in California, I believe. I don't know what it is in New York.
Right. Yeah, I mean, that's definitely something to look at, the statute of limitations, but we should note that, that there was a move for dismissal of all this, and I think we should definitely break that down, because it's really interesting. I think it's very interesting what what arguments are being put forward. And I think, a couple quite compelling, I think. So yeah, I think maybe we'll get some inkling as to where this is headed.
Okay, cool. Do you want to, well, what's that mean? Are we still going through the main complaint?
Yeah, we're still going to the main
Okay.
complaint. I just wanted to,
Yeah, no, go ahead.
point out some important points, regarding, fan reaction defenses here. So,
Okay.
yeah, so I think, so the most common defense I was saying is defamation is truth, and and I think I made a comment about that there. The second would be that the statement was just Keemstar's opinion. However, since it was stated in a factual way, Def Noodles has allegedly groomed girls, it's hard to see a viable defense saying that this was just Keemstar's opinion. Essentially, when he 8 months later, to your point, retracted it and in effect said he knew it was untrue and not his opinion all along. So consent and privilege won't apply as defenses here. California also has an anti-SLAPP strategic, so that's strategic lawsuits against public participation law, but that doesn't seem to apply here either, because to prevail on an anti-SLAPP, the court must find that the defendant, Keemstar, was acting in furtherance of his First Amendment rights in connection with a public issue, and second, that Def Noodles had failed to show any probability that he will prevail on his defamation claim. So here, clearly, Keemstar was not speaking about a public issue, since he admitted he made it up and was just trolling Def Noodles. And Def Noodles was shown a probable
because he already admitted that. I gotcha.
Right. And then Def Noodles has shown a probable case of libel per se. So for purpose of this, I have left out analysis of a public or private figures, issues of public or private concern, or the statute of limitations, since they generally won't apply. However, it is worth noting that both Def Noodles and Keemstar both probably qualify as public figures because of their very, very large social media following, and that the statements about the P word may be issues of public concern given their subject matter. In California, courts require the plaintiff to show actual malice when speaking on an issue of public concern. So even assuming that a court found the statements of Keemstar made to be a matter of public concern, it does not seem possible that they were made with malice, and thus nullifying this defense as well. So but I think maybe switching gears to the dismissal. So on the 5th of August, the defendant, Keemstar, filed a motion to dismiss the complaint against him filed by Dennis Feitosa for slander per se. And this motion just to dismiss is based on, if anyone's looking it up here, FRCP 12b6 and FRCP 12b1, which state that a claim must state a specific claim to which relief may be granted. And there is definitely some very relevant facts I think we want to highlight. We just went through the complaint. It's a lot of information, but at the same time, I think we should pick out about 7 key facts, I think 7, 8 key facts here in looking at the filing to motion to dismiss.
Okay, I do have the filing here I can pull up. I finally found the other one as well.
Okay,
but,
good.
Yeah.
Okay.
Sorry, I should have had that up, but
oh, no problem.
We're learning how to do this. All right, Chrome. Are you like somebody that has only one thing up at a time, or like my problem is I have too many windows?
I tend to have a lot up at the same time. I do, and I'm almost like, like I hesitate to flip around too much, because then you like lose it, and then you really, you're like I'm trying to find it and trying to find,
yeah, exactly. Okay, let's see here. So this should be the, let me try to make it bigger. Okay, here we go. So this is the motion to dismiss. So this was filed by Keemstar.
Right.
Do we know anything about the judge yet? Do we know who the judge is?
No, not yet. Not
Okay.
in my research.
Okay.
But I can do more.
No, you're good. You're good. All right. So let's see here. Okay. Where should I go? So this is a motion to dismiss.
Just the
Harder seat. So these are his
facts
attorneys.
section.
Okay.
Yeah, yes, just at the beginning with the facts. I think we should highlight a few things here before we get into it.
Okay.
All right. So so the defendant notes that Def Noodles show is full of disclaimers, which state Def Noodles is a character meant to satirize, sorry, some of the most deranged, toxic, and destructive aspects of internet culture. The opinions and thoughts expressed by Def Noodles are not a reflection of Dennis Fetosa's beliefs. So putting that out there. The Def Noodles character is supposed to be a cat in a Minecraft video game house. Although the cat in a Minecraft house is played by Fetosa as live action and is just Fetosa in glass and cat ears with Minecraft house backdrop. Okay. So that's the image of it. Fetosa makes it very clear that he views Def Noodles as a fictional character only. He also posts often ending his posts with words like, "We have reached out for comment," when in fact, he never did, just because the entire post was meant as a joke. So the defendant's pleadings give
Fetosa does that? He's saying that Fetosa,
Fetosa
does that?
Mm-hmm.
Okay.
The defendant's pleadings give a larger context of war of words that was going on in the days prior to the defendant's allegedly defamatory tweet. On May 18th, 2021, Fetosa posts, "These Skype messages show two people discussing Keemstar's allegedly having the 13-year-old girl get nude on stream, as well as the streamer Cupcake." On May 19th, 2021, Keemstar allegedly abusing his girlfriend in resurfaced videos, and Keemstar then allegedly yelling at his girlfriend. We then hear screams and shouts, and the mic cuts off at that one point. And then she later pleads with Keemstar, quote unquote, "Stop it, you psycho." Okay. On May 20th,
what page are we on here of the lawsuit?
these are all the facts that listed out. Yeah. I'll highlight
is
through
this on
next
the
time. What I'll do next time is I'll highlight through.
It's okay.
So exactly where
this is on the, are we on the this is on the
beginning. Yeah.
This is the motion to dismiss?
Yeah. And
okay.
These are the key facts.
Okay, go for it.
Yeah. So so then on May 20th, 2021, and
here we go.
I would say this one's a little messed up, everybody. Keemstar allegedly bullied an 8-year-old special needs child on Twitter, and when confronted about it, allegedly said that if he didn't do it, then someone else would. So after May 21st tweet by Keemstar, which is the issue of the suit, Fetosa continued with tweets such as, and then here we go, on June 27, 2021, and then on June 30th, 2021. So on June 27th, Keemstar scammed fans with cryptocurrencies allegedly. And then on June 30th, 2021, Keemstar is a known liar. He is the R word apologist. He's an infamous R word and an anti S word.
Okay, so right here, May 20th, this is messed up. Keemstar, this is what Def Noodles posted. Keemstar allegedly bullied an 8-year-old special
Yeah,
needs child, blah, blah, blah. Okay.
that's ugly.
Um,
Yeah.
okay. And then 31, May 31st, quote, this is another post. Secondhand embarrassment. Keemstar tries to leech off Aiden Ross by inserting himself into Aiden's beef with Ludwig and Soda Pop and immediately gets destroyed. Okay, but I saw that YouTube that he's referring to there, and that was like a fair description or opinion of
Interesting.
what may have happened. Yeah, because these people are all going live on each other's YouTube. So, okay, but so anyway, and then so here he says David Dobrik exposed. Keemstar embarrasses himself. So this one could be an opinion, right? Keemstar embarrasses himself. Okay. And then June 27th. Meanwhile, Keemstar scammed fans with cryptocurrencies, allegedly. Keemstar is a known liar. He is a R-word apologist. He's an infamous racist and anti-Semite. I think that's because of another drama where he said something about Jews. So I guess that's maybe where he's coming from there. July 1st, 2021, very scientific study. Is Keemstar a ... scammer? So he's asking people. Okay, so so basically now Keemstar's introduced all these things in there.
Yeah.
As basically is he trying to say like I'm getting bullied by Keemstar?
Right.
Like to show the judge the context. Okay.
Right. Yeah. So, right. Kind of, setting the whole thing up here. So, I mean, laying it out. Defendant wants the matter dismissed because the subject matter tweet is not of and concerning Feitosa. So what this is referring to is California defamation requires first a publication, second a falsity, third a defamatory, fourth an unprivileged, fifth has a natural tendency to injure or cause special damages. So a publication, and it is false, defamatory, underprivileged, and has a natural tendency to injure or cause special damages. So California courts have also found that defamatory statements must specifically refer to plaintiff to be of and concerning plaintiff and therefore actionable as libel per se. In this case, the defendant argues that since the tweet in question does not reference Feitosa by name, this is really interesting, I think, and only Def Noodles, who is a fictional character called to the facts, as cited, it is not of and concerning Feitosa and therefore not actionable. So California—
I have a question though.
Yeah.
Oh, go ahead. Go ahead. What were you going to say?
Yeah, so California courts consider the totality of the situation in determining if the statement is of and concerning a plaintiff, and this requires the nature and full context of the communication content and the knowledge and understanding of the audience to whom the publication was directed. So defendant then argues that since the tweet in question mentions Def Noodles, not Feitosa, it is not of and concerning Feitosa. And the defendant argues that Feitosa himself has said that Def Noodles exists solely as a comedic personality and does not define or encapsulate Feitosa. So then the entire tweet, according to defendant, does not refer to Feitosa by implication, and that there is essentially no way to read it that it would allow a reasonable person, so drawing back to the test, to draw the inference that it was about Daniel Feitosa, the person, not Def Noodles, the imaginary cat in a Minecraft house. So as such—
I have a question though about that. Let's just say that is the case, that Def Noodles is just an imaginary character. If Keemstar would have said this about, let's say, Big Bird or Barney or Mickey Mouse, couldn't like Disney like sue for that type of thing? Isn't it still defamatory, like to say Mickey Mouse is a P word? And I mean, it wouldn't it be damaging to the brand?
I mean, that's quite interesting, but here the difference is obviously this imaginary character has always been associated to one person, whereas Barney, the character Barney, all these characters, is not necessarily always, um, people, um, the person behind the mask, so to speak, the Wizard of Oz, um, is
Mhm.
obviously a corporation with many multiples, including stand-ins when people are sick, etc.
Yeah.
As that person, and the and I mean, you probably know better than I, but what is what is the team behind this person, right? I mean, when you have a ginormous team like Disney, I mean, it's
I guess I'm just saying, like, Mickey Mouse is an imaginary character, but saying something defamatory online about him that could be retweeted or um, whatever,
Mhm.
I think it would still be damaging to any brand or any character uh,
Mhm.
if it caught wind. So that's just my thought, but keep
Mhm.
going.
Yeah, I think I think that I'm actually, I think this is an interesting point to research actually, coming out of this. So yeah, and
Just because, like, for example, with my case, like, it's me, Ariadne Jacob, and Influences Inc. suing Taylor Lorenz and the New York Times because they referenced my company name and my name in association, with each other. But I could have just sued under Influences as well, and so I think
well,
at least that's what I think.
yeah, and there's actually did some quick looking here, and there is there is a there is a line between protected free speech and online defamation, a fine one there, and business defamation, a type of tort claim here, where you have an alleged false statement, a fact about a plaintiff that had caused the plaintiff to suffer financial harm. So looking at that financial harm. So, um, so I think, I think that it's all about what's proven in terms of that suffered actual harm. And it's not just about hurt feelings, it's about what that harm is, spreading lies about someone, etc., and hurting reputation and resulting in other, sort of tangible things.
Okay.
But maybe part B of this
Yeah.
of this segment here. Um,
All right. Well, I'll let you get through more. So
but
those are
the
the
answer
things.
to your question
Yeah.
is both individuals and businesses can file defamation suits.
Right.
But the elements of those, are a bit different, and how they're applied.
Okay.
So yeah. All right. So um, let's see. I think I was right. So with all of that argument here that he presents is he says, okay, well then Feitosa was not defamed as a matter of law, from that, from his analysis of the of and concerning element. So then he goes on to say that the complaint has to be dismissed because under the totality of the circumstances, again, another part of the test, the subject tweet is not reasonably susceptible of an interpretation that implies that the tweet was stating a matter of fact. So the defendant argues that the tweet deserves First Amendment protection and that the courts will engage in a context-driven inquiry considering the totality of the circumstances in which the statement was made. And whether a defamatory statement is a fact or opinion is a question of law for the court. So California applies then a 3-factor test to determine if a contested statement implies an assertion of fact or instead non-actionable opinion. First, the court has to look at the statement in a broad context, including in context of an entire work setting and format. Second, the court has to look at a specific context and content of the statement, the extent of the hyperbolic language used, and the reasonable expectations of the audience in the particular situation. And then thirdly, the court has to consider whether the statement is sufficiently factual to be susceptible of being proven true or false. In its broad context, defendant argues that since Def Noodles is a fictional, always a joke character working in a realm where hyperbole and where both parties take constant jabs at each other, this kind of thing is really expected. This was a part of a larger war of words with specific phrasing, the allegedly, emphasis there, being used everywhere. This is the culture known and understood by the people who consume this content. So the defendant argues that part 2 of the test also fails because in the narrow context of the tweet itself uses the allegedly format. And so I think you picked up on that earlier. Who's using the word allegedly? I am, but
Yeah.
them. And the no comment was given format that Def Noodles used in many of his posts. So the defendant then argues that the tweet contains no accusation of sexual or specific illegal conduct. And then also many comments posted after the tweet was posted showed then an understanding that it was a joke. And many people did not take it seriously given their understanding of the culture, the format of the tweet, and the expectations from the back and forth that have been going on. So then the defendant argues that this was a statement made during a war of words, and as such, was really no assertions of objective fact, and indeed cites case law then stating a quote unquote, a heated and volatile setting may make seemingly factual statements take on an appearance more closely resembling opinion than objective fact. So then finally, the defendant then claims that the statement itself is not sufficiently factual to be susceptible of being proved true or false. Allegedly groomed is not detailed enough, and the word groomed can have various meanings, and maybe make the point that since so I mean, maybe we come,
So this is the case that they did, the Terrain versus Lou. They're the defendant, among other things, called a plaintiff a racist P word after the plaintiff, a radio diss track.
Yeah, so Def Noodles is a cat here, a cat creature. So maybe grooming could be seen in like the cat cleaning itself, possibly, is where he's going with this. The reasonable expectations of the audience, given the overall context of the culture, the nothing is seriously the nothing is serious mentality, and the war of words going back and forth would stop a reasonable viewer from
really thought.
Yeah,
I don't think anybody ever really thought though that the Def Noodles was an actual cat. Like, I don't know. I feel like going back as they go back and forth, they know who's arguing with who for the most part. But I get what he's saying. I mean, I get how it's smart how they did this, how they kind of referred back to what Def Noodle said he is. I don't know.
Yeah.
It reminds me of, did you ever watch the Hulk Hogan Gawker case, or did you hear about that?
I did hear about it, but I didn't really get much into it.
There was one part where they were trying to say that Hulk Hogan was not a public figure by saying that the video was not of Hulk Hogan, but of whatever Hulk Hogan's like real name is. And so Hulk Hogan like gets on the stand, and famously they're like, well, Hulk Hogan said on the, on the Howard Stern show that, he had a 10-inch penis or something like that. And then Hulk Hogan's like, well, Hulk has a 10-inch, but Terry Bollea, that's his real name, doesn't have one. And so, but in that case, they were trying to prove the opposite, that, or I don't know if they were trying to prove the opposite. They were just trying to, similarly, they were trying to prove that there was two different people at issue. So it was like, it's kind of just hilarious the way that it
is. My God.
Yeah.
Wow. Hulk Hogan. Gosh. Yeah,
I gotta find it. I feel like it's funny enough to like where these guys would laugh.
totally. Yes, I agree. Yeah.
Um,
Um,
so, so what else did you put
so
anything else to as
yeah,
note?
yeah. Lastly, I think something to dig your teeth into here on this motion to dismiss is that is that defendant really argues here that the complaint must be dismissed because Vetosa has not suffered or pleaded damages meeting the 75,000 amount in controversy for federal court jurisdiction, and argues, there's really no showing of actual damages, no loss in subscribers or viewership, no loss in income due to the tweet. And really, since the federal jurisdiction is predicated on the amount of controversy being at least 75,000, and since Vetosa hasn't shown any actual damages, and indeed, I don't see it in this motion to dismiss. As a matter of 12B1,
Do they have to put damages in the original lawsuit?
They
The complaint?
they should break it down. They should break it down, but it can be brought up. Obviously, if this moves forward and is not dismissed, in further stages of the case, in discovery as well.
Here's this clip. Here, let me play it really fast.
Let me ask you this. Let's see if we can simplify this. Do you have any doubt as you sit in that witness stand today that you were discussing the length of your penis on Bubba's radio program? Any doubt?
Well, it's not mine because mine isn't that size, but we were discussing the length of Hulk Hogan's.
Seriously? So,
oh my gosh.
No, seriously, I do not have a 10-inch penis. No, I do not. Seriously.
fair enough. So what you're telling us is you were discussing
Believe that,
Hulk Hogan's
seriously.
penis, right?
Excuse me?
You were discussing Hulk Hogan's penis.
Yeah, because Terry Bollea's penis is not 10 inches like you're trying to say.
Like, imagine going over this like with your client. Wow. Like, okay, this is what you're gonna say.
Gosh.
That's just so funny to me.
Wow.
Okay.
Yeah.
So, oops. Okay. All right. So what's next? So do we go through what else is important on the
so just really that, okay, so since federal jurisdiction is then predicated on the amount in controversy being at least 75,000, and since Vetosa hasn't really shown any actual losses as a matter of 12B1 subject matter jurisdiction motion, defendant is asking the court then to throw out the complaint with totally with prejudice, therefore then precluding Vetosa from refiling this in state court.
Got it.
So that's a key chess move right there. So
requesting to do it with prejudice.
Yes, indeed. Yeah.
And what do judges typically do that, or?
Yeah, they certainly can. Mm-hmm. So it'll be interesting.
Like if they just think it's really ridiculous, if they think there's no way of winning, or they think it's not viable, then they'll just do it with prejudice. Is that right? Or what would make them do it with prejudice versus not with prejudice?
Well, you're not supposed to be bringing frivolous claims to the court. And, I think he's laid out a pretty interesting motion for dismissal here to say, this is the nature of what we do. And, so if you kind of sign on for this, then he knowingly, he knew this. And, they certainly can, invoke with prejudice and say, I don't want this to keep coming across, for us here, for us courts. So, yeah.
Okay. I guess the other side of it is that people might say, hey, these people have been at this, and hurt other people's reputations potentially.
Right.
And so this needs to be looked at,
Right. Yeah. To make an example. Indeed. Yeah. And, well, we'll see what then ensues from this. But I think it's
So any final thoughts?
You know, I think it is well put together, the motion to dismiss. I think you know, I mean, I can see why. At the same time, I can see why the complaint was put forward. I mean, obviously, you know, and I mean, there's just so much online, and you know what influencers, I mean, what their followings can do, and what kind of you know, hurt to people's reputation can amount to it from there. That I think this is definitely something newer that the courts are having a look at right now. I mean, this is.
What do you think is each person's best argument?
So I think it was a good argument to say that Def Noodles, you know, that this is, you know, this is the character, and you know, and that it's a little hard to, it's not put into question really that whether it was in fact you know, an injury then, because you know, it's only Def Noodles, it's not a reference to Fetosa. So I think that is actually a good argument to put forward, because it's very pervasive throughout the channel and what he puts out there. And there's lots of evidence about that, this kind of comedic personality. And you know, I think that, you know, that, so yeah, I think that would be
one of the things that I didn't understand is, like, for example, I can understand why somebody would say that, like, for example, a comedian saying something about someone, even if it were, you know, sort of like exactly what Keemstar said, it depending on how it was said, that some people may know that it's a joke, versus, but you know, I guess what I didn't understand about the Keemstar motion to dismiss is Keemstar is not alleging that he is a jokester only, which that would make more sense. It's like, what I don't understand is, why didn't Keemstar's lawyers just say, well, you know, nobody really takes what Keemstar says seriously, like sort of that like Rachel Maddow defense or whatever.
Mm-hmm.
I wonder why they didn't claim that, because I could see that moreover than, okay, because I think it could be taken as a point of opinion as if he's talking about Fetosa or Def Noodles, just because that was his account. So what, I don't think Fetosa has a personal, I don't know if he had a personal Twitter account or not, but when Keemstar's tweeting at Def Noodles, which is ran by Fetosa, you know, just a normal person looking at Twitter might assume that this was being serious, versus like, I'm wondering why they didn't say, you know, use that defense of, well, you shouldn't take what Keemstar says seriously anyway. Or did they say that at all on here? Because I didn't see that.
I didn't see that either. Yeah, but certainly it's repeated over and over again that these are like there's constant jokes being made, constant, and but I think the complaint is doing a good job of pointing out that, hey, it kind of feels like this is being taken a few steps further here, significantly. You know, the Twitter account was shut down, so there was no like I couldn't respond, I couldn't defend, I couldn't, you know, so.
Did that happen right after that his Twitter got shut down?
I believe so. I had gone through the.
Got it.
It was
yeah. Well, that is kind of terrible.
So
like
February 5th,
and back on Twitter.
Keemstar tweeted and then reposted, and then blocked Def Noodles. So 8 months went by after, yeah.
Okay.
So, I mean, it kind of feels like, I mean, because, you know, I mean, you would probably be able to say better than I mean, isn't this kind of, you know, when this kind of thing types happens where allegations are made, back and forth influencers, they're kind of batting back and forth a bit. I mean, they're given an opportunity to voice a response, right? So this situation, it felt very, I can't even defend myself, So,
Right.
so I think that was, clearly a part of the fact pattern for damages here. And, and then when you look at the remarks on the fan reactions, I know that you brought some color to that, though, and some you had some more personal sort of understanding of what some of those reactions were. But I think the points are being made here is that certain defenses just don't apply because they're that. It was stated in somewhat of a factual way, and so, so yeah, but it's definitely a toughie. It's mucky here. This is definitely mucky, and
it's not a clear one on, like, you're like, not like, oh yeah, for sure it's gonna get dismissed, or
well,
yeah.
I mean, the
for
plaintiff,
sure.
you have to show actual malice.
You have to show malice before it even moves forward.
When speaking of an issue of public concern, right? And
Wow.
so but
So how will they determine? Okay, so
it just seems like there. I mean, really, was there malice here? That's the question. Was there really malice, or was this just another jokester type maneuver? So, I mean, yes, the sequence of events, yes, all of that, but they're.
So is Dennis's team going to be able to then come back and say, this is why we don't want it dismissed? That's what happens next, correct?
Well, yes. I mean, the judge will also look at it at this point too. And they will be able to make a determination whether they're going to allow this to proceed or not. So.
Got it.
Yeah.
But I think for my case, my attorneys came back with something else from the motion to dismiss, and then they came back with something on why they believe it was like there was two more chances to basically, not chances, but there's two more opportunities to argue if it should be dismissed or not. Do you think that will be the case here, or is it just up to the judge if they're supposed to respond back with a?
So they have about 14 days to respond to a motion,
Got it.
dismiss, and and they get a chance to amend the original complaint in California, and sort of fix the problems that the defendant identified in that motion to dismiss. So let's see what happens there, so that. That here can happen. And, I mean, in California, anyone can sue for anything. So lawyers can file many different motions.
But this was filed in New York, so
to just dismiss the case. So they're slapping
the judge
people in the face and going, this shouldn't even have been filed. But they're given an opportunity to amend. So.
Do you think that at this point the judge hasn't ruled whether California rules apply or not?
Right, exactly. So that needs to also occur.
Why do you think they want California rules to apply?
The damages, and also the a lot more flexibility with being able to bring suits in California than other states. And the history and precedent on defamation suits, particularly after, clearly we've seen Johnny Depp and Amber Heard. So, so that would be my sort of, 2 cents on it. But you're also springing these questions on me sort of like in the moment.
Oh, no worries. No worries.
You're giving me like no time to kind of,
No.
prepare anything, so.
No, I'm just curious if you knew off the top of your head. We can go into this stuff. I mean, I was just curious. I think I'm guessing that probably they, just from my experience, I wonder they've probably filed in New York, so it wouldn't get anti-slap. Because so if you get if the judge decides it's a strategic lawsuit for public participation, then you could be liable for paying the defendant's legal fees. So I guess that's like the big kind of scary part about filing a lawsuit
Right.
for defamation, which is kind of, I think it was meant to protect the little guy initially, but now it sort of protects the big guy also. This is a case of sort of equal people, but I'm talking about like if you're suing a major publication, like, the LA Times or whatever, then for a private citizen or somebody with not a lot of money to sue a big publication like that, and then if it gets dismissed, have to pay legal fees. I mean, that would deter most people from filing a lawsuit, I'm guessing. So if there's no anti-slap in this district that they filed, then maybe that's why they did that. But I'm curious why they did, why they're trying to apply California law. But
Right. I mean, yeah, it's with the
choosing
two
a venue is a lot.
different states. I mean, it really
Yeah.
should be a federal case. So so we'll see.
So you agree with the venue that they filed in?
I agree. Well, again, I think that goes to kind of what they're trying to essentially get out of this
Got it.
and what case precedents they're trying to pull from in their
Okay.
favor. So I think that does make sense from their perspective, but being from different states, it should be the federal court would be the proper
Got it.
venue, proper jurisdiction.
I have a question, by the way, because I've never understood how this happens, where they put in all the different cases that have happened in the past. Like, how does an attorney find that? Do you guys have some like system where you go in?
Texas. No, there's a few very important, I want to call them kind of databases that we use.
Okay.
But ultimately going to your law library too. I mean, that's a thing.
Wow.
Still.
And
but
do you have typically have like researchers like within the law firm that do that? They go through
yeah,
and
absolutely.
they do like keywords
As well as at the law
Interesting.
library too. And there can be very large teams put together on these points, and
Wow.
so critically important, those citations. And many judges are very picky about how that's presented. So
Wow.
yeah.
Interesting. So obviously a team that has more access and more resources are going to be able to dig through old cases much more than a smaller team.
Depending on the size of the suit, I mean, sometimes you'll see other law firms even collaborating with bigger law firms to help to support, depending on how big the suit's getting. So, yeah.
Interesting. Yeah. And I think it's interesting, a lot of people I don't think understand with attorneys, a lot of you guys have very specific wheelhouses of what you focus on. And, I think with these new defamation things happening, I wonder, just because, most like I've seen, I think I was talking to Ron Coleman. They do a lot of First Amendment stuff, but he was saying on the podcast, he's like, I actually advise my clients not to sue for defamation. It doesn't matter if you've had hurt feelings. Like, I think with my situation with the New York Times, it was like very clear. Like I went from having a business to not having a business at all. So that's like, but I think for most people to prove, that this happened because of this particular moment in time can be super challenging. That's not to say that I think that, people that actually defame and libel people should be able to operate sort of with impunity. But, and I think recently, even one of the Supreme Court judges wanted to talk about potentially overturning the whole New York Times versus Sullivan situation because I'm really curious. One of these cases is going to bring up the fact, like, is so-and-so a public figure and how are we figuring that out? Right.
Mhm. Right. That's why I put that analysis in my talk. Yeah, absolutely. And I think that's really interesting from an influencer perspective, because that is a very 2022 movement. So,
and it's like everybody has a lot of people have a YouTube account and a Twitter account and a Facebook account who are not public figures, or who, and it's also, how do you go back to that moment? Let's say this happened a year ago, for example. It's going to be hard to sort of know, like, how many followers did so and so have then? I was even thinking about it for my case, like, how are they going to know? I mean, now I'm verified on Instagram because I've done some other things publicly, but when the actual complaints that we listed were going on, I was not verified. I had maybe, like, I don't know how many followers. You know what I'm saying? Like, how are they going to actually dive into this stuff? So I think this stuff is super interesting. But, and then go back to, like, I don't know if you paid attention to the Alex Jones stuff, but that one, he really didn't have, he didn't really get to even plead his case.
Right.
So I wonder, how the judges are going to go in these various cases. It's interesting.
Yeah, it's I think that what we're doing actually right now is so important to the whole process, though, too. And it's almost like the public is also kind of figuring out their own reactions and how to what influencers do is help to almost, in a way, shape or represent public opinion in some ways, or even engage with and allow people to also engage with them in a way that we don't have. You look at a television, you look at Netflix, you can't, but this is, real life, real happening. And, and things get heated. And with that, like there's this, you want to, I mean, what are some of the very authoritarian regimes do when they are oppressing? They shut down public debate. They shut down the ability for people to gather and talk and give their opinions. And, we have, like, what is a leader nowadays? What is an extraordinary person nowadays? That could be defined as an influencer. That could be someone who is willing to challenge opinion, or willing to challenge, a certain situation, or bring forward a potential injustice. And, they may not be a doctor or a lawyer or an engineer, but they are presenting, this scenario and providing, some may argue, a very important service to society. And, I think it kind of goes back to, some of those original writings on what is polity, what is what are we now? What are we now in 2022? And how do we, we're so kind of disconnected, but in ways we're also at the same time so connected with our online and our digital, coming through a pandemic here. It's I think it's quite interesting how the courts are going to react in terms of whether they will use the arm of justice to put what kind of limitations and boundaries on this new type of forum, this new type of public gathering and talk that we do, which I would say is very important, with our progression as we move forward. But yeah, very interesting. And I think this case, I think Emily Baker was very right to bring up this case. And we'll see what happens, especially since it should go federal. So,
okay.
Yeah.
Cool. Well, thank you for breaking everything down. Hopefully the people in here watching, or the people who watch later on your channel, if you guys have questions, I put all of both of our social media. So if you want to tag us on Twitter or leave questions in the comments, maybe we'll do, when we see what happens next, we'll do another one. And don't forget to catch Lorraine. We're also going to publish, she did an in-depth video about Brittany Griner, the two-time Olympian women's basketball player that is held in Russian jail right now because of cannabis oil possession. So Lorraine is really passionate about just, educating people on that. Hopefully we can get Brittany and the others home. And if you guys have any, I guess, ideas of what you think we should cover next, I mean, I'll actually just put out there real quick the ones we talked about. And then if you guys have any opinions of if any of these are interesting to you, there was a skin Kardashian lawsuit, SKKN. There was a Zac Efron Netflix sued by company over Down to Earth show. There is, let's see. I don't know what other celebrity lawsuits are going on. Hailey Bieber skincare trademark lawsuit. That's kind of more in your wheelhouse too. Lorraine, since you guys do trademark, but really open to anything you guys are interested in. And there hasn't been any updates on the Ricky Martin case, which that was Lorraine's first video. Right?
It's gone quite quiet right now. However, we should be hearing something soon. I would say with Brittany Griner, it's such an interesting intersection between, immigration, athletes of extraordinary ability who are immigrating. I mean, coming into the US, you have to get very specific visas for this. And going into Russia, China, many of these states worldwide that WNBA players are traveling to, are, have different laws, have different rules. And so I think it's a really interesting case, obviously extremely tragic and absolutely just, there are no words, I would say. But it's this immigration and sports and entertainment and, stuck between two superpowers in the middle of an ongoing war and conflict in the Ukraine. So please get tuned into that commentary on Brittany. And let's do it.
Okay, cool. All righty. All right. Well, thank you guys. Like and subscribe and share this video, and follow Lorraine on YouTube. Let's get her so that she can start going live. And we'll see you next time. Bye.
Bye.